The next matter for the court is State of Ohio versus Kyle Spy.
Good morning.
Good morning.
Good morning, Mr. Pierce.
Good morning, Your Honor.
Again, the state has waived its oral argument, its right to present oral argument, and so you have 15 minutes to present your argument, and we've read the briefs, and we're ready to sort of hear what you have to say.
Thank you, Judge. May it please the court, first, thank you for my client and myself for rescheduling the argument so that I could be here today and complete the argument. It's my way of trying, and my client's way of trying to emphasize that this is an important matter to him and an important matter to the law as we know it in the state of Ohio. The subject matter, of course, is a murder case that Mr. Spy was convicted of. That is, he was convicted of purposely causing the death of a Terry Iverson. It's called a special felony. There was a gun specification included, and he was convicted and sentenced to life in prison. That is 15 years to life in prison. There was nothing unusual. I guess that's kind of an odd word to say about a murder case, but there was nothing unusual that stood out in this case. No facts that would shock the world or recall for you anything about the case. It was a routine, mundane murder charge, and Mr. Spy appeals from that conviction. There was an incident that happened during the trial that we think was important enough to merit Mr. Spy having a new trial in this matter. He's now presently served some year and a half, maybe 2 years in the Mansfield Correctional Institution. Coinciding with the trial, he pled guilty to having a weapon while under a disability and was sentenced on that to, I think, third-degree felony to 3 years in prison as well. The disability was said to be a prior conviction for domestic violence, not involved in this particular case. The interesting thing to me about this case is, one of the interesting things is that Mr. Spy was 23 years old. The deceased, his friend, was also 23 years old. His name was Terry J. Iverson. And there is no evidence that people heard that there was any reason for Mr. Iverson to be shot by Mr. Spy, nor for Mr. Iverson to shoot back at Mr. Spy. Now, that's so something was going on behind the scenes, perhaps, I don't know, but that's where it was. It happened out on Wildwood Avenue on May 16th, 2000.
Counsel, are we speaking in terms of what you just said about no reason for him to shoot? Are we speaking of any motive that was developed?
That's true, Judge. I am trying to speak that way.
Okay. And along those lines, I recall in reading the briefs that your client had a girlfriend who actually testified for the state,
That's true.
and that just immediately before the shooting, that she had gone to purchase some food and had brought it to your client and had some money stuffed in her bra area, that the victim reached in and took it and counted it and then gave it back to her.
That's also true, Judge.
And so when you say that there's really no reason for either of these gentlemen to have a dispute with one another, would you consider that as something that the jury might have considered?
I don't know. There could be some suggested rivalry between the two men for little Crystal's favors. I don't know. But that's not in the record. At least enough, any more than what you described.
Certainly.
Although Crystal was, Mr. Spy's girlfriend, in the fact that she had lived with him for 10 days, I think, prior to Mr. I'll call him TJ's death.
They dated for 10 days, or they lived together for 10 days?
I'm
So they dated for 10 days.
The record shows, Your Honor, that they lived together. See if I... The record shows at page 295 that they had dated 10 days prior to TJ's death, including spending the night before TJ's death together at her apartment. What we're complaining about is the fact that the trial court refused to admit as an exhibit a certain photograph or video of TJ Westfield, or TJ Iverson in a car, driving, brandishing a handgun. The court had several reasons for not doing that. Neither of the two reasons do we believe were valid under the law. But in what that was we believe was relevant evidence, and we believe that that evidence deprived Mr. Spy of due process, and I cited the cases that you say that, and it was significant enough that he should have a new trial.
And tell us about the photo and why you believe that it should have been admitted.
Yes, thank you, Judge. And that's the focus of this particular case. It's because of the facts of this particular case that this photograph or video becomes so important. There were two eyewitnesses who testified that they were two eyewitnesses to the shooting. The fact is that Mr. Spy is accused of shooting Mr. Iverson about 5 times with a weapon that was never found. Mr. Iverson was not accused of shooting a weapon except by an eyewitness. Let me back up. Bill Crystal is sitting on Wildwood Avenue in her car. The record shows that Mr. Spy is standing next to the right fender up front of the car. That he has a gun at that particular time. Apparently it's not visible. A gun that is never recovered. Mr. Cunningham, Anthony Cunningham, is sitting on Wildwood in his car, just apparently across the street from Little Crystal. And he sees the events that occurred. And he describes the events as Mr. Iverson going over to the car where LaCrystal sat and talking with her and laughing with her and joking with her and taking the money as you described and putting it back in her bra. And as he's walking away, Mr. Cunningham describes the fact that Mr. Spy came over with a gun, and he saw Mr. Iverson pull from his jacket, that is, Mr. Cunningham saw Mr. Iverson pull from his jacket a handgun and fire it at Mr. Spy, at which point Mr. Spy responded with fire himself.
Was that the weapon that was found in the road?
And where, Judge?
Laying in the road? I thought I read that there was a handgun in the road.
Yes, no. That weapon was later determined by experts not to be involved in the case.
It wasn't the one Mr. Iverson had allegedly?
No, it wasn't Mr. Iverson. I'm sorry, Judge, I should back up and say we don't know if it was Mr. Iverson's. We know from the ballistics reports that there were 12 cartridges found in the street. Those cartridges matched the same gun, but since there was no gun to match it to, they didn't match the gun that was found in the street. The gun found in the street was fully loaded, about 7 bullets in it, and was not found to have fired those cartridges. Let me back up a little bit because it is confusing. So you've got Anthony Cunningham sitting on one side of the street testifying that he sees TJ pull out a gun from his handgun from his breast pocket and fire it at the defendant. The defendant then responds with his weapon and shoots TJ at least 5 times, we think. At least 5 slugs are removed from his body by the coroner. And those slugs all match the same weapon, but there's no weapon to match it to. It doesn't match the weapon on the ground. So Anthony Cunningham describes a case of self-defense for Mr. Spy. Mr. LaCrystal says that TJ has no gun that she saw, never fired a gun, never pulled a gun on Kyle Spy, that he just came around the corner of the car and fired the 5 or 12, whatever it was, slugs at him.
So tying the photo to the importance of the photo, what did the photo represent?
The photos support Mr. Cunningham's version of the events.
In what respect? Did they just show this?
In the respect that he had a gun in his possession at the time of the video. They had, and also 2 people testified, relatives of Mr. the deceased, that they never saw him with a gun during his lifetime.
So what is in the record as to how the photo was to be authenticated? Is there proper?
Yes, there is. The defendant's attorney says that he's going to have Mr. Cunningham, remember he's the eyewitness on the street, Mr. Cunningham testified to that it was TJ in the photo, and that was a handgun.
And so it's not clear from the briefs, but my question was whether or not anyone was able to say when the photo was made, where the photo was made, or in any way tie it to the day of that occurrence.
I don't know if anyone was able to or not, but apparently there was no proffer to that effect.
Okay. And you have about 2 minutes, a little less than 2 minutes remaining.
Good, thank you. I just want to mention a couple other things. Ballistically speaking, if that's a phrase, a BCI expert testified that Mr. Iverson had gunshot residue on his hands and I think on the front of his jacket. And he testified that one of the causes of that is to have recently fired a firearm. So you're confronted with the fact that you've got two eyewitnesses who say opposite things, one of which could be supported. And there's no evidence that Mr. Iverson ever had a gun. In fact, the evidence is contrary to Ella Crystal said she didn't see one that night. He didn't have one. His mother said that he never had a gun. And his aunt, who he lived with, her grandmother, said that she never saw a gun with Terry during his lifetime. He's 23 years old. But then you've got gunshot residue. So how does the jury work its way out of that? In addition now, a BCI expert testifies that since there's no gun, there's at least 2 or 3 guns on the premises. One is the loaded weapon that was found on the ground that they eliminated as firing the slugs or the cartridges. One was the weapon that fired the cartridges, and one was the weapon that fired the slugs. They didn't necessarily have to be the same weapon. In fact, the expert could not tell without a weapon whether they were fired by the same gun. There were also there was a cartridge, a .22 long caliber cartridge found on the street at the scene, which was explained by the state. It could have been fired, could have been ejected from a handgun, and in the experience of the examiners had in the past been used in handguns and ejected and was laying on the street.
You have reached, Mr. Pierce, the end of your 15 minutes. And we will take the matter under advisement. We will issue an opinion. We'll send a copy to you and to the state. And you can certainly look online on the Supreme Court's website for the opinion.